Kevin Horner of Gallagher and Manning. Thank you for joining me. I wanted to talk about a topic that's come up a lot recently for us professionally. It's the kind of things that people know are really important, and more than almost anything in estate planning, they never seem to get to or actually put into practice, which is dealing with who would be the guardian of minor children, and essentially estate planning when you have minor children. People assume, and at this point, I'm not going to go through this aspect in detail because if you've watched Kevin's Corner at all, you know this, that you should just have an estate plan before you have kids. So I'm not going to talk about why that's important to have if you do have kids. You should not assume everything you own is going to go to them. I'm just going to talk about today what to do with minor children in your estate planning. First and foremost is naming guardians for them. Now what I mean by this is if you and your spouse or the parent of the child are both unable to basically be parents while they're minors, the court needs to appoint someone, really probably two someones, to take over essentially in loco parentis in the stance of the parents for that kid. Now that means guardian of the person who's, so to speak, you the legal guardian, the parent, who will help make decisions, what religion they're going to be raised, where they're going to live, what kind of schools they're going to go to, those kind of decisions. And then separately guardian of the estate, which is the person in control of their money. And if money is going to be owned by them or a decision needs to be taken care of for them while those kids are minor, the court is going to appoint a guardian if you both pass away to do that. So what can you do to make that awful circumstance better? First and most obviously is you have the ability to name guardians. Now, the exact method by which you will do this depends upon your state. In Texas, it's a standalone declaration where you name somebody. In other states, sometimes it is part of your estate plan itself. Sometimes it's a standalone thing. I should say part of your estate plan meaning sometimes you found it in the will. If here's who I want to be the guardian. Other times it's a standalone document. And no matter what the method is, it is one of the principal reasons why you should make sure you have an estate plan set up if you're going to have minor children or you have minor children. Obviously, there's a huge window where you want that in place where, unfortunately, it does happen. We have it happen all the time in the office where there has to be a guardian or someone appointed because there was an unexpected and young death. So that's first and foremost. You want to make sure that person's nominated. Number two, you want to think very carefully, even within your estate plan, what and how you're leaving things to those minor children. I feel like most attorneys will not make this mistake, but LegalZoom definitely would, is that if you have a basic will that says I leave everything to my spouse, then to my kids, and you and your spouse both die, and everything is being left to a 3, a 5, and a 7-year-old, they're not legally old enough to own anything, to receive property. There's nothing to do, which means there has to be a guardian even for that little portion of money, regardless of what else they may own. So you and your own estate plan can change that. You can leave everything to them in a trust. Some people do a very simple contingent minors trust, which essentially says if they are minors, I'm going to appoint a person just to hold the money, to administer it on their behalf until they hit a certain age and then they can keep it. That's very standard, very basic. It's the minimum of what you'd want to do. And at least for the money to leave through your estate, you have a good chance at least of avoiding guarding the estate for the kids. Much better than that is to do a trust that's more robust, that can provide other things other than just simply not breaking down, such as creditor protection, divorce protection. You might not think of it when they are 3, 5, and 7, but at some point those things are all going to be realities for them. And getting it all done at one time is a great way of having continuity in the estate plan and ultimately saving you money because you don't need to replace it or amend it many times as all those little things change. And this would involve leaving them a trust themselves, never having the trust end, and letting them just become in charge of it when they hit a certain age. 25, 30, 35 are all pretty common ages. And it's a good way of avoiding a guardian for that money and to just have good continuity in your estate plan. And then third, sort of tied to it, is another place where people often don't realize that they're going to make a mistake. I can think of one case I used to practice in New York where this was one of the sole problems. It was life insurance from a grandparent to a grandchild. Grandchild was, I want to say, 15. And the insurance form just simply said to that kid. And what this means is if you're going to leave things through beneficiary designation, which a lot of people do because they think it's going to avoid probate and that'll all be good. If you're going to leave it to a minor, they may or may not have to have a guardian appointed or someone to hold the property for them, a custodian or whatever is going to be appropriate in your state law, named inside the beneficiary designation itself. So if you look at your IRAs, your 401ks, etc., sometimes they have built in there the designation that if they are too young, so-and-so will be the person who's in charge of it. If you're going to leave things to minor children and you're not going to leave it to a trust where the person in control of it would already be designated, you definitely need to do that. Now, there might be a method to bypass depending upon your state or again upon the forms, but especially when people are young, they don't have a lot accumulated in the state yet because they've had debt, they've come out of college, they're paying for things, etc., but they are starting to build up, say, retirement from their 401ks or their jobs. And a lot of their value is outside of the estate and it ends up getting into that same trap because there's no one designated to control it. So to quickly rehash that, it is one, you want to make sure in whatever is appropriate in your state, here we do it by declaration, in Pennsylvania you used to always do it in wills, you want to have guardians nominated, that's definitely a conversation between you and your spouse. You want to make sure you leave things in an estate plan to minor kids that does not just simply leave it to them. You have at least some plan to let an adult control it for them until they hit at least a certain age. If not, do better than that and get creditor protection, divorce protection for them. And then third, any beneficiary designations going to a minor, make sure it's covered there as well, especially if that plan already gives you the option to address it with them. So those are just a couple of key points. Basic early estate planning is not complicated. It doesn't have to be complex. You can do that which will cover you for 50 years, or you can do something more simplistic for the short term, but it is very critical to do it. People don't use it often, but when they do, if they don't have things set up properly, it's devastating to a family with minor kids. It's a lot of court involvement, a lot of work, a lot of difficulty. So with that, if you have a situation like that and you want to make sure you get taken care of, by all means be proactive. You can call our office or go to our website, galliganmanning.com. We'd be happy to help you with that. So thank you very much, and I will see you all again next Thursday for Kevin's Corner.